Good evening, and welcome to Suffering in Silence with Minister Tia on Love Bay Afrobeat Music Talk Radio. We're here with you every Friday evening at 7 p.m. Eastern. Love Bay family, we're continuing to rise out of the ashes together. Our topic on this evening, we will be covering the process of obtaining PFA'S. We have with us, our guest this evening is Jennifer DiPillo. She is an Esquire, director of the Crime Victims Law Project for Delaware County Victim Assistance Center. Listeners, if you have any questions or comments for our guest, you can email us at sufferinginsilencedv@gmail.com. You can also text your questions or your comments to 437-778-3299. And if you have any resources that you would like for us to share on a national or local level from your country, your community, your local organizations, or your faith community, you can also email us at sufferinginsilencedv@gmail.com. And with that, Jennifer, would you take a moment to introduce yourself to our listeners on this evening?
Sure. Thank you, Minister Tia. I appreciate the invitation. I'm going to apologize outright that my camera is not working. I got all dolled up for the event, and now you can only see my picture. So I'm sorry about that. My name is Jennifer DiPillo. I am the director of the Crime Victims Law Project, which works through Delaware County Victim Assistance Center. I've been there off and on since 2001. I have two attorneys that work for me currently, and we handle mostly family law issues. We help all victims of crime, but we also do some landlord tenant, Title IX, contract issues. We sort of tell our staff to just bring the stuff to us, and we're going to see if we can handle it. If we can, we do. If we can't, we try to refer out to another organization that can.
Awesome. Thank you so much. And we want to share Crime Victims Law Project. The address is 204 South Avenue. This is in Media, Pennsylvania, 19063 in the United States. And the phone number is 610-566-6463. And some other resources we have to share with you, Love Bay. Pastor Darius Daniels, pastor of Change Church. His website is dariusdaniels.com. His YouTube channel is Darius Daniels TV. We have the Ontario Native Women's Association. Their website is www.onwa.ca. Their phone number is 1-800-667-0816. We have Befrienders Volunteer Action to Prevent Suicide. To find a helpline by country, you can visit their website at www.befrienders.org. And then we have the Canadian Women's Foundation. Their website is canadianwomen.org. Their phone number is 1-866-293-4483. And with that, listeners, Love Bay, we move into our topic, the process of obtaining PFA'S. So, Jennifer, I would ask if you would first start by telling us exactly what is the Crime Victims Law Project? What was it designed to do, and what exactly do you do? So, if you just expand a bit more on your
Sure.
introduction.
So, a few years back, we changed our name to Delaware County Victim Assistance Center. Before that, we were Delaware County Women Against Rape. We were initially a rape crisis center back in the 70s. We were opened in 1974. Our former executive director, who's no longer at our agency, was an attorney and decided she wanted to have a law project because she felt that there was a lack of legal services for victims of sexual assault and other sexual violent crimes. So she went in with three other rape crisis centers in our area in Pennsylvania. So it was 4 counties altogether: Delaware County, Bucks County, Chester County, and Montgomery County. And they got a grant from the federal government to get the law project up and running. That's when I was hired in the very beginning. Over the years, we've had a lot of changes and pared things down. So I am only now working in Delaware County. The other agencies sort of dropped off. Some did their own projects. I'm pretty pretty sure none of them have a law project right now. So we've been continuously running since 2001. Like I said, it was initially for sexual assault, and stalking was another area that we were able to assist. Over the years, we were able to expand that by getting different grant funding where we can help all crime victims. We find a lot of the cases that we're getting more recently, unfortunately, are due to gun violence, where we have a murder victim's family. Usually, a grandparent will want custody of a grandchild when their son or daughter was murdered. We have a lot of those cases coming in now. And the vast majority of the legal cases that we handle are protection cases. We get a lot of those. In the county that we're in Delaware County, we have one day a week where we have those hearings. That's Thursday. Usually it changes a few times a year, but for the most part, it's Thursdays. And on average, we probably have between 80 and 100 cases a week. So it is a large number. My associates and I, we probably handle, it depends week to week, but last week or the week before, I think there were 5 or 6 cases that we had. And there are different types of protection orders in Pennsylvania. And everything that I'm going to be talking about tonight is all based in Pennsylvania. You may find in other states and in other countries you have something similar, but I'm going to give the specifics about what happens here in Pennsylvania and specifically in Delaware County. In Pennsylvania, each county has their own local rules. So it's also going to shift a little bit county to county in Pennsylvania, what it looks like.
Okay.
In Pennsylvania, we have 3 different types of protection orders. One is what we all lovingly refer to as PFA'S. So that means protection from abuse. That's the original protection orders that we had for years and years. Back in 2014, we added 2 additional protections. So the original PFA is meant for family members related by blood or affinity, which is marriage. So it's usually that there's a relationship there. Those are the ones that you see: husband, wife, boyfriend, girlfriend, significant others. It's not a restraining order. It's not something that you would get against a neighbor or a friend. You have to have some kind of a relationship. The second type that was enacted in 2014 was it's called the sexual violence protection. And that is for only sex crime matters. So we always had this gap where I would have a student come to me and say, I was raped on campus, and it didn't qualify for a PFA, the traditional PFA, because they didn't have a relationship with this person. It was a co-ed, somebody maybe that they knew from class, in the same dorm, etc. So this SVPO now helps to bridge that gap. So now it is, if there is a sexual crime, you don't have a relationship with the other party, you can get a protection order. The third type is called a protection from intimidation. This one is extremely specific. We don't see very many of these overall, maybe a few a year. The victim has to be a minor, so under the age of 18, and the perpetrator has to be an adult, so over the age of 18. And it's usually some type of harassment or stalking. I've had a couple of them where it's a neighbor yelling racial epithets at another neighbor's child. We were able to get a protection order under that PFI for that client. But it is very specific. We still do have a gap here in Pennsylvania for straight up stalking. You know, an example: in California, we have a lot of movie stars out there. You have a lot of strange people that think that they have a relationship with that movie star and may follow them around, try to get into their house. You hear those stories a lot on the news. They're able to get restraining orders in California in that scenario. We are not. We don't have that. Stalking is not covered under the sexual crime. And unless it's a minor victim and an adult perpetrator, it wouldn't qualify for the PFI either. So we're still lacking there. With those 3 protection orders, it all operates the same on how you would go about obtaining them. First way is what we call an emergency protection order. And that is if the courthouse is closed, so after hours, weekends, holidays. So it starts at 4:30 p.m., goes until the courthouse opens the next day at 8:30 a.m. It would be for weekends, like right now, if somebody needed to get an emergency protection order, they would contact their local police, and that the police department would instruct them what local district justice is available to hear their case. They would get their case heard before the district justice. I had one recently where the district justice did a phone interview, didn't even have the victim come physically to see them. But there is paperwork that needs to be filled out. I'm sure there's a way to fax or email to get it there, so that the judge can sign off on that order if they agree that there is a need to have this protection in place. The caveat with this is that you have to go back to the courthouse the next time that it opens to file for a temporary protection order. It is a very short window of time that you have this protection. It doesn't last very long. It really is for emergency purposes. If you know that you can wait until Monday morning, we recommend waiting until Monday morning, because you're doubling your efforts. You're doing the same thing multiple times. You would go back to the courthouse on Monday morning. In Delaware County, we have a designated desk that you would go to. They provide you the paperwork, they explain it. They don't give you legal advice. They make that very clear. They will not give you legal advice, but they will direct you on how to fill it out. It is very, what we say, pro se friendly. That means it is very friendly for people to do on their own. You don't need an attorney to fill out this paperwork. Once the paperwork is completed, you are then escorted to a courtroom, and you go before a judge. Every judge sort of has a different way that they run their courtroom. Some may ask questions, some may not. Some may read your petition, see that there's enough information in there for them to make a decision and say, yes, I'm going to grant this order. Some will ask questions, follow-up questions, sort of make sure they understand everything that's going on. So they will either at that point grant or deny your protection. If it's granted, you then have to go back to that counter and get copies. And then you have to go to your local police station, as well as the police station for the defendant, which may not be the same police station. You might not live in the same place. So you'd have to go to 2 different police stations and drop off the paperwork. At that point, the police then have to serve that paperwork on the defendant. This is the part that I think a lot of people don't realize is going to happen. The defendant's going to know, and the defendant then has an opportunity to appear in court and defend themselves against what you've said in your petition. So that means you have to come back to court, and you're going to have to be in the same courtroom as this individual. So we always, at the Crime Victims Law Project, make sure that clients understand the entire process and that they're fully aware of what's going to happen. We do put protections in place, and I'll talk about that too, to make sure that they're safe when they're in the courthouse. But it is something that I think a lot of people aren't expecting. They think they're going to go in, it's granted, and now they don't have to do anything else.
Yeah.
Once
I'm sorry. So, do you work specifically with the Domestic Abuse Project of Delaware County?
We do work with them. We're not linked to them, but we work well together. They are in court every week as well as our legal aid of Southeastern Pennsylvania. They also represent victims for protection orders free of charge. All 3 of our organizations do that.
Mm-hmm. Well, so just in thinking of specifically dealing with domestic violence, I know that an advocate or a representative from, if speaking of Media, Pennsylvania, an advocate from DAP will go with you to apply for a PFA and walk you through
Correct.
the paperwork.
And an advocate from our office will as well. If we know in advance of you filing the paperwork, somebody will go with you and walk you through that entire process. The PFA timeline is very quick. It is one of the quickest legal processes that exist. Typically, justice is slow. In the protection order arena, it is very quick. Because we have those cases every week, your case is going to be heard usually within 7 days. So you're going to have to come back within 7 to 10. 10 is the maximum by statute. It has to be heard in 10 days, the first listing of the hearing, the first hearing. There's a lot of things that depend on whether that's going to happen. So did the police serve the defendant? Mm-hmm. We have to find that out. Maybe the defendant doesn't show up. We don't know. we have to get there and figure everything out at that hearing on that Thursday. When we represent a client, if I know that they are terrified of seeing the defendant, we have different locations that we will have our client go that is safe and secure. And I will only call them to the courtroom if it's absolutely necessary. Sometimes it's not. It may be that we're getting a continuance. I would say 90% of the first listings for these cases are going to get continued for whatever reason. Either the defendant wasn't served, the defendant wants an attorney. We maybe are going to negotiate if maybe he has an attorney and we're going to start some kind of negotiation and we want to continue it so that we can try to work out maybe an agreement moving forward.
Mm-hmm. So can you talk more about the difference between a temporary order and a permanent order? Because I know some individuals think that if it's gotten after hours or over the weekend, falsely believe that that temporary order is all that they need. So can you talk more about the difference of
Sure.
the temporary and the permanent, the importance?
So there's 3 levels. So it's the emergency, which is the after hours. Temporary is what you get before you have your hearing. And then a final order would be you either have an agreement with the other side that they're going to enter into a final order, or there's a hearing and a judge makes a determination that it's a final order. So we have a lot of cases where there may be a companion criminal case that's happening at the same time. So if there's that can go on, here we go with the justice is slow, that can go on sometimes 2 years or more. We still have a little bit of a backlog because of COVID. So there is a longer turnaround time for some of these criminal matters. If the criminal case is ongoing, typically we're not going to have a hearing on the protection order. That temporary order is going to stay in place. That temporary order is just as good as a final order. It has all the same protections. It just has a date attached that you have to come back to court and figure out what you're going to do next. The emergency order that I think you were talking about earlier, Minister, is that after hours and you have to go to the courthouse to get the temporary as soon as the courthouse opens the next business day. So if I went today, right now, and got an emergency order and it was granted, that's only going to last me until Monday morning. And I have to go Monday and file up at the courthouse in Media in Delaware County to get the temporary. Now, the temporary orders, there is nothing in the statute to limit how long you have a temporary order. So going back to a criminal matter that goes on for 2 years, we could continue a temporary order for 2 years or more, then have either a hearing and get a final order or have an agreement to have a final order, and we can get another 3 years on top of that. For final orders, there's a maximum of 3 years. What we've been seeing in Delaware County is some of the judges are doing, when they're granting them, they're doing less than 3 years. They're doing a year, they're doing a year and a half, but the maximum is 3 years. So we try to get the maximum for our clients at every possible moment.
And whether it's temporary or permanent, when that order expires, is there a notification sent to the plaintiff, to the victim? Will they know full well in advance that this order is expiring and given a chance to have it continued? Or is it just done and, we just don't know?
That's a great question. So the temporary orders, like I said, they have a date attached. So that is a date where you're supposed to come back to court.
Mhm.
Once you have a final order, you no longer have a date. You're no longer required to come back to court, but there is a date on there, and we do go over that with our clients. So there'll be an end date, and they'll know what that end date is. Typically, it's 3 years. So if it was 3 years from today, we're talking 2026. It's going to expire. We often have clients that reach out either before or after it's expired and say, I really need to have this extended. So there is an option to extend protection orders. I will say that it is not easy to do, in that the court wants to see something. You can't just say it's expiring and I don't feel safe. That's not enough. They're going to want to see there's a reason behind it. Like maybe he's getting out of jail and that's coinciding with the 3 years. So
Yeah.
now if he gets out of jail, and you don't have a protection order, I think you have a reason to be fearful. You don't have any protections now. If you haven't seen the person, haven't heard from the person, there's been no contact over the time that you've had the final order, the court isn't likely to grant you an extension. With that being said, what I like to tell clients is, if it does expire and you're not able to get an extension and something happens after that, you can go back and get another one. That's you're never precluded from going back and trying again, as long as there's something that happened. You can't base it back on the same facts from before.
Right. And so several times in speaking to individuals, and I know counselors have shared, speaking to specifically the issue of domestic violence, victims and survivors are told when issues happen, when situations come up, record what is going on, write it down, keep your paperwork. It can be tedious, it can be annoying, it can even be hurtful to have to sit down and make notes trying to keep track of what this person is doing to you to harm you or hurt you in some kind of manner. But I think what you just said is an important reason of why we tell individuals to do this. Keep this information, because if you have to go back into the courtroom to either get the PFA in the first place or to have it extended, then you can say, this is what this person has been doing to me or is continuing to do.
That's absolutely correct. I have a client right now who, it was a former boyfriend who was stalking her, literally, like driving past her house all the time, parking in her driveway. It was just really unsettling. We were able to negotiate with him. He didn't get an attorney that for a final order. A year and a half goes by in this order. He wasn't doing anything. Then all of a sudden he starts driving by again. She went to the police because she called me. She said, what am I supposed to do? I said, go to the police. She makes a report and they say, well, it doesn't say he can't drive past her house. So we go back to court. We do a modification. That's another option where you can modify the terms of the order. So we went back into court. We modified it. He had to appear as well. So he had to be notified of the modification. He comes to court and I say, will you agree if we rewrite this to say that you can't drive down her street? And he said, well, I might have to drive down for an emergency. And I said, fine, we'll say if you do it continuously, that it may rise to the level of an indirect criminal contempt, which is what happens if you violate the protection order. So he agreed to that. Another year goes by.
Can I ask, why does he have a choice? Like if he is stalking this person and there was already an order in place and now it's just being modified, like why is he being asked if he agrees?
We're changing the terms. And so legally, I can't just change the terms without him having notice and having a say. Okay. And he really didn't want to change the terms, but I was able to negotiate to get him to agree to the language that I put in there. And it was really important. And this is honestly, and this is the other thing, it's a more global problem. We have a lot of different police precincts in Delaware County, and they all operate differently. And so what might rise to the level of the police acting in one jurisdiction may not in another jurisdiction, and that's problematic. I have a huge problem with that. We do, in my office, we do trainings with the police, and we try to encourage them to do things the way that I think they should be done, that make victims safer. Whether or not they follow through with that is another story. But this individual, getting back to that stalker case, he then continuously drove down her street, and she had a Ring camera. So I said, go to the police. So she goes to the police. She brings her Ring camera footage, and now he's charged with indirect criminal contempt, which means he's violated the protection order. That's what that specific crime is. He was also charged with harassment and stalking. So now that criminal case is playing out in the courts.
I think it seems unfair. Specifically, I'm thinking of just an example of siblings, young siblings together, and how they just can pick on each other and bother each other. And I know sometimes, and I did it with my brothers and sisters, we would be near each other and one of us didn't want to be bothered and the other was just so close enough, but just to say, I'm not touching you. but it was bothering the other,
Yes.
and then my mom would
Yes.
say, stop it, cut it out. I just, it's kind of like that, where in a normal situation, if someone is driving past my house, it wouldn't bother me. But if this person drives past your house and you have a history with them, they've intimidated you, they've harassed you, they've hurt you physically, mentally, or emotionally, just this person driving past your house, walking past your home, even being within a few feet of you, that is a fear that another person wouldn't have. But because it harms you in that manner, um, it's like, I don't understand why. And again, dealing with domestic violence and sexual assault, why the victim's word or experience isn't taken into account in a manner where, yes, this PFA, this protection from abuse order, is going to be granted, because what you are doing to the naked eye, to someone else, it may be a normal activity, but you doing this to this person, it is harmful. It is abuse in some kind of way. And
That's exactly right.
yeah, and it's the burden of proof is like on the victim. So I have, if you, every time you call me, I have to write this down. And
Right.
if I change my phone number and you get a hold of my number again, I have to make note of this. I have to make note of this.
Yes.
And it's
And Minister Tia, it also goes to the judiciary and how they interpret it. And that's where I've struggled myself, because you and I both are trauma informed. We understand that. We understand. And I always, when I do trainings for police, I always say, if the victim comes to you and says, there were roses on my car, to you, that doesn't seem like anything. That seems like a lovely gesture. There's roses
right.
on my car. But to
Exactly.
her, she knows that she got roses when he was drunk and came home and beat her. And that's the association that she has. So it shouldn't be an objective standard. It should be a subjective standard based on that person's level of fear and being uncomfortable, afraid. The problem is, I think our judiciary doesn't have that train. They do get it. I will say they do get it, but being trauma informed is not a training. It is a way of life, and you have to know that and live it. And our judges don't, unfortunately. And I think that's the hard part. I can't tell you how many times I've had judges. I had a horrible case where it was a child that was raped by a neighbor, and he had moved away, but then would come back to visit whoever was still at the house. And we went back into court to say, like, he shouldn't be there because of exactly what you're saying. This is very traumatic for this child to even see him, and he didn't live there, so he had no right to be there. And the judge would not find in my favor. She said, I can't stop him from going to somebody's house if he's invited. And that hurt a lot. I mean, I've done this work for a really long time. That's probably the one of the cases that I came home and cried. It's sad because there's reasons why we have these protections in place. And unless and until you either get the training and practice what you preach, or you've been a victim yourself, you don't
Yes.
understand it.
Yeah. And I really wonder, just an honest and straightforward question, how can you get to be a judge? How can you get to be a lawyer, whether it's prosecuting or defense? How can you get to a particular level in your career, or even operate in a particular career, and you're not trauma informed? There's not mandatory training. Like, I think of accountants every year. If you want to maintain your license for a CPA, there's training you have to do every year. There are specific
Yes.
careers. There's training that you have to stay up on every year to say, I've taken this training. I know what I'm doing. I have the new information. I don't understand how, when you're dealing with victims and trauma, and especially children, if you're dealing with children and these issues come across, how is this not mandatory for those in our judicial system to have this
Yeah.
training,
I mean,
and not just
they
take
get
the credit, but understand it and demonstrate it?
right. So attorneys have to take 12 credits a year of continuing legal education, but you get to choose what you take. And different attorneys go into different areas of the law. So, if you have somebody that does corporate litigation or does bankruptcy, they might not need to be trauma informed. And
Yeah.
I do think it's very useful for everyone to be. So don't judge me there. I think it's very useful, but I don't think other people think it's useful for them because they're not dealing with victims every day. But when I go around and speak, I tell people just because I'm dealing with victims doesn't mean that your client, who may not be a victim of anything, isn't also experiencing trauma by entering the courthouse. It's scary, it's intimidating, it's new. They don't know where they're going, they don't know what they're doing. And that in and of itself is traumatic.
Mhm. So I want to ask you. I want to ask you two questions. First, I want to ask. So you've given the definition of three protection from abuse orders. First, it's dealing with relationship. You're related to the person you're trying to get an order against. The second situation was dealing with sexual violence, and the third situation was the protection from intimidation, dealing with an adult and a minor. What if you have a situation that does not fall into one of those three categories? Is there anything that you can do? And my second question, if you do fall into one of these categories and you go for it and your request is denied, what would you advise someone to do?
Right. So um, I have oftentimes found that things make their way through, even though they don't qualify. So I had a case years ago where it was straight up stalking. This guy worked with this woman, decided to put a tracker on her car and was popping. She didn't know there was a tracker on her car. Obviously, she would go to a bar, she wouldn't mention it at work, and he'd be there. She'd go somewhere to the store, he'd be there. Um, when she filed, I guess it was maybe it was the sexual violence. I don't remember which one she filed under, but I was up like the night before, really stressed before the hearing because I knew it didn't qualify. And I knew all the defendant's attorney had to say was, this doesn't even meet the statutory guidelines for this and should be thrown out. And it would have been granted, and I wouldn't have had any protection for this woman. He didn't. So sometimes people aren't up on what the statute says. Maybe they do criminal law. They don't do protection from abuse all the time. They don't know all the little nuances. So I was able to get that. So I don't ever discourage someone from filing if it doesn't really meet the criteria. We always say, if you really want this, like, go ahead and try it. I mean, it's worth a shot. We'll see where we're at. We'll do our best. We'll try. Um, in the event that it's denied, you still are entitled to a hearing. So you may see that judge for the temporary, and maybe you didn't put enough information in your petition. Maybe you were really scared, and in being trauma informed, I know that victims don't always put all the information they need down. They forget things.
Yeah.
They're doing it on their own. So we can go in and have a hearing after it's denied on the temporary level and possibly get it. I've actually gotten them after they've been denied on the temporary basis. So it's not impossible. But in the event that it all fails and it's denied, I sit down with my client and we do safety planning. And like going back to what you were saying before about writing everything down, you can make it easier. You could voice memo into your phone. We do encourage our clients to call us to assess whether or not they should be going to the police, because I know people don't want to call the police and bother them about, he drove past my house. They
Yeah.
feel like that's, you're taking their time away from something more important. We try to encourage people, no, you should call them every single time, because every single time they're going to take a police report, and that is paperwork that is important. Attorneys love paperwork. We love to have a paper trail. So that is very important. But in the event that you don't want to, I've had people that had very bad relationships with their police, their local police, and they didn't feel comfortable reporting it. So then you're gonna make sure that you document it somehow on your phone, because dates and times, they fly out of our heads as time goes on. You're going to forget. It's very easy to forget. But we do specific safety planning with our clients about things that they can do to keep them safe based on their specific circumstances.
Hmm.
We do have access to crime victims compensation in Pennsylvania. So and I don't want to go off rails about that, but it will sometimes give you some money to help you relocate. if you need to relocate. So, I often have conversations with clients, and yes, I feel terrible about having to have these conversations, but what I say to them is, okay, I know that this is a lot on you and you're the victim and you shouldn't have to do all these things, but you have to worry about your own physical health, mental health, and well being and safety. And so these are the things that you have to do to get there. Nobody's going to do it for you, unfortunately. And unfortunately, as well, a protection order is a piece of paper. And so it's not a bubble, it's not a bulletproof shield, and if somebody really wants to come and kill you, that protection order is not going to save you from that. So we safety plan with all of our clients. And when I first started many years ago, it was, maybe call a neighbor and let them know you're leaving your house or when you come back so that you have somebody that's sort of watching your back. Now with the phones and cameras, we have all that stuff right in our hands, which is great. So, if you see him driving by, you can take a video, and then you have it documented. Safety planning is very important. And unfortunately it does fall on the victim to have to do that.
Yes. Well, I'm glad that you said that because that was a point that I was going to bring up. A PFA is a piece of paper, no matter which category it falls into. If you can get it, you should get it. But as we're doing this program, I did not want to leave anyone with a false hope or false impression. If you have a protection from abuse order, everything is going to be okay. So I love what you said about safety planning. If you go through the process of getting the PFA, you still need to do safety planning. You still need to be mindful. That does not mean that you can or should drop your guard of, just being mindful of your whereabouts and who's around you. Right. And, who you spend time with. I think it's an important step to take if you need to take it, but you don't stop there. Unfortunately, individuals have still been hurt, killed, and they did have active PFA'S. So it's not the end all be all. It's something important to do if you need to do it. But again, I didn't want to put any false hope, into
it's a tool in a toolbox. It's not a shield that's going to protect you necessarily. It does work a lot, but and the police are our friends. I mean, I do encourage people to utilize their local police. It is very important. They need to know you're not a bother. That's their job. And our office also helps to bridge the gap. If you're somebody that's not comfortable with the police, our advocates will go with you to the police department. They'll talk you through like how to make the reports, how to go pick them up. They'll go with you and make it a little bit of an easier process.
That is good to know as well, that is something that your office would assist in. My experience with the police, I've always had a positive experience. I've never had a situation that was out of pocket or harmful. So, but I know that's not everyone's story. I know that's not the case for everyone. But it would be great if we all had officers around us that did their jobs.
Yeah, I mean, I have, that one case that I gave you the example where the police were saying just because he drove down your street, we can't do anything. It has to say he can't drive down your street. I had another case in a different jurisdiction where the state police were the local police, and it was this was during COVID, and both of the parties were in recovery programs. And so we were trying to avoid them going to the same ones. So this gentleman did attend a Zoom. It was not even live, a Zoom meeting with her. Didn't do anything, didn't look at her funny, there was no other parameters, just he was on there and he wasn't really supposed to be. She called the state police and they went and they arrested him. So, I mean, that's the huge difference. And I wish it was that way for everyone. So the other thing I want to address quickly too is what happens if you violate a protection order, right? So the crime that you get charged with is called indirect criminal contempt, and that the police are the ones that make that determination if they're going to charge or not. So that's why it's important to really keep them informed of everything too. I understand the whole not wanting to bother. I hear that a lot, but it is good to let them know what's going on, because sometimes it's not one instance that's going to cause them to file that charge. It may be that there's repeated things that are happening, and they're seeing, repeated driving down the street or repeated phone calls. Maybe it's not just one phone call, maybe it's not just one thing. So that's important. When they get charged with indirect criminal contempt, the penalty for that is up to a year in prison. I'm sorry, up to 6 months in prison and up to $1,000 fine.
Okay.
In I don't do the contempt cases, because that is the district attorney's office that handles those. But I do sort of a warm handoff with my client, and I will help get what she wants across to the district attorney. Um, Typically, it's a negotiated resolution. I've only seen a few people go to prison, and it was pretty egregious stuff. So, and I've never seen a fine. So it really doesn't have a huge amount of teeth. What ends up happening is the defendant will be asked to do maybe some kind of a class or do drug and alcohol evaluation. Sometimes the protection order gets extended for even longer. But typically, it doesn't really have very sharp teeth. I also counsel clients about, if you have a defendant that was convicted of a crime, let's say, they have the right to get a protection order because that's civil. The criminal process is completely different, but the penalties are hugely different. In the criminal case, if somebody is on probation for their crime and they violate the protection order, they're likely going to go back to jail. They
Mhm.
wouldn't have that as a penalty if they didn't have that criminal case going at the same time. So um, you don't need the protection order, and at that point, typically, if you have the same time frames involved, if someone's in jail, let's say for a year, and then he's going to be on probation for 2, the maximum you can get a protection order is 3 years, and that is your right to do that. And a lot of people do that because they then have a piece of paper that says he can't contact me. When
Yes.
you go through the criminal process, you don't get any paperwork at the end. You're the victim in that case. You're not a party to the action. It's the Commonwealth of Pennsylvania versus the defendant. So you're apprised of what the parameters are on his probation or parole, but you don't physically have it in your hands. So I understand why a lot of my clients want that paperwork as well.
Yeah. Um, as you were speaking in the previous example you gave, I thought of something when you talked about both parties being in a recovery program. There are some individuals who do not want to or feel that they can't request a protection from abuse order because they themselves may have an alcohol or drug abuse problem, or maybe they have committed some kind of crime or something. They feel like I've done something that's not going to allow me to go through this legal process.
It does
Can you
not bar
address that?
you from
Yeah.
filing. I will say that I always ask clients to be really honest and open, because you have a privilege with me, and I'm not allowed to share that information that you provide to me unless you say it's okay.
Mhm.
Um, but being prepared for a possible hearing and that coming out in a hearing is really important. So if it's relevant, so we have rules of evidence in the law. So it's only allowed to come out if it's relevant. I mean, if the parties were, both drinking heavily, during whenever the incident happened, it may come out. But somebody being in recovery, it isn't really part of the story
Mhm.
necessarily. And if we can keep that stuff out, we will. Um, it's not a detriment to you getting it. It's just part of the process, part of the story. If it needs to come out, we'll talk it through and make sure that the client is comfortable with everything. But it's very important to be honest with your attorney. Very important, even if you think the facts are not favorable to you. We find that a lot, where people don't share things because they think it's going to negatively impact their case. And what I often say is, I'm not good if I'm surprised. That's not going to be helpful to you. If I am prepared, I'm going to be much better. So if you give me all of the information I need, then I can work it through. It's the same kind of thing with it's probably more relevant in custody than anything else.
Mhm.
If somebody has a drug and alcohol problem, that's a problem for custody, and we will counsel our clients about that.
Mhm. Thank you so much for that answer. I want to ask you, I know we've talked about just the differences in counties. There are differences in each state, and that's all in the United States. I want to ask you, is there much of a difference, or do you know, or is there much of a difference dealing with protection from abuse orders internationally?
Yeah, I don't know the answer to internationally. I've done a couple
Mhm.
custody things that were international, but not protection orders. Protection orders are supposed to be honored state to state. So if you have one in Pennsylvania and you go move to Delaware, New Jersey, wherever, it's supposed to be honored there. Different jurisdictions may require you to like file it with their courthouse. You would have to look. The length of time for protection orders differs greatly. So in New Jersey, you can get a lifetime protection order. We don't have those here, and I have a
Mhm.
lot of clients that are like, I don't understand why. It's just different. The Protection from Abuse Act is a statute, so it's somebody that drafted words, and it was legislation that got passed. So that's why it is what it is here, and it's different in another state.
Mhm. So can I ask you, when you're dealing with individual orders, is it a case by case basis on it being determined? This person cannot come within several hundred feet of me, or this person cannot be at the same place that I am. So
Right.
is that a case by case decision if it's
Well,
a place or a
actually, it
distance?
doesn't say that. The terminology doesn't say um, about feet, right? Like
Mhm.
I do remember when I was a kid having a restraining order in Philadelphia, and that was different. There was some kind of parameter with how what the distance was.
Mhm.
This we don't have a distance. It says that there's all different boxes that we check off, and it is you're not allowed to contact the other party. You're usually evicted from the home if you're talking about, a domestic type situation.
Mhm.
Um, it reiterates multiple times that you're not allowed to threaten or harm the individual, but it doesn't talk about space and time. Like,
Mhm.
and that's where I think a lot of the judges get caught up too, because it's not in there as a specific spatial requirement. I've even had judges say on the stands, like, if you go to Wawa and he shows up, he doesn't have to leave. Well, I counsel my clients a little differently. Um,
Mhm.
I sit down and I tell defendants the same thing that I tell my client. If my client walks into the Wawa, like if I know this is going to be a problem because they live in the same area,
Yeah.
my client walks in a Wawa and sees him in there, I would say to her, you need to turn around and leave. It's better for your mental health too. And also, if something were to happen, you're in a better position to get him charged with a crime and possibly get your PFA extended. If you try to
Mhm.
do this stand your ground stuff and say, I deserve to be here, you have the protection order, I don't, it doesn't look so great in our court system when you do that. They
Yeah.
do have the right to be there. She does have the right to be there. And so if she chooses to be there, she's not going to get in trouble, but it does set you up sort of for failure if you want to try to claim that you're afraid now of him and he did something. Um, I do tell defendants, the same thing. If she's there and you walk in, you should turn around and walk out. Like if you're already in the process of making your coffee and she walks in, I don't expect you to drop it and run, but I do expect you to finish your transaction and not say a word, not look at her and walk
Yeah.
out.
Mhm.
Those little nuances are very difficult for the court to grasp. They're I haven't seen, and I'm just using my own experience of what I've seen and how they've ruled. They don't like those. They will say, he didn't threaten you. He didn't, he didn't even look at you. So how can you say that you're upset? And you and I already said it doesn't have to rise to that level. That person is traumatized by just seeing him, right?
Exactly.
But they don't look at it that way, unfortunately.
Mhm.
So it's that's part of our whole process with, the safety planning too. I will say, look, if he knows that you always go to this Wawa on this street, you're going to not go to that Wawa. You're going to try to switch up your routine so that you have less chance of running into him
Mhm.
for your own mental health and well-being.
Yes. Um, and so, and also, normally part of the conversation, thinking about PFAs, I think we, especially doing what I do, dealing with domestic violence, my first thought usually is there is a woman going to file this order because there is a woman who needs protection from an abusive male partner. But can you speak to the issue of men filing for protection from abuse orders and how, I mean, if you are a man and you need to do this, then you need to do it. It needs to get done.
Yes,
Speak to men who say, I don't want to, I don't
I've
want to, go that
right. It's
far.
stigma, right?
Yeah.
I've represented a few men over the years, and I feel like it is becoming a little more um, frequent. And when I say frequent, it's not frequent, but more frequent than it used to be. So we do see men filing against women, and some of it you'll see joint filing. So woman will file and then the man files, and then you have to figure out who's telling the truth, right? And are you going to grant both of them, or are you only going to grant one of them? But men file as well, I think, probably at a hugely lesser rate, because again, stigma. And
Mhm.
I think men don't want to look weak, and so they choose not to do that. But I do see it sort of opening up a little bit more as time has gone on. I mean, I've done this for a long time, so I think you're starting to see more of it.
Mhm. Well, I do want to stress, it's not a one-sided issue requesting protection from abuse orders, just like domestic violence is not a one-sided issue. Anyone can be abused or hurt. Anyone can be in need of a protection from abuse order, be you male or female, adult or child. Finances don't matter, education does not matter. So I do want to be encouraging to our listeners, no matter where you live. There are some answers that I do not have internationally. There are some answers that I do not have out of the state of Pennsylvania because I'm inside of Pennsylvania. But wherever you are, I encourage you to find resources, to find information, to find what you need. If you reach out to any domestic violence agency, especially the national agency wherever you live, they should be able to guide you and direct you into whatever direction you need to go. So look for it, whatever you need. I know we don't have all the answers, but whatever you need, look for it. You have that power to ask questions and seek out information in whatever way possible, whatever you have at your fingertips. So
And Minister, we've come a long way. I know it used to be really hard for me to find different agencies in different states. Like if I had someone that said, "Oh, I'm moving," or I live in Minnesota. We have the internet now, so you can find things so much easier. There's tons of nonprofit programs all over the country that do the same types of work that I do, that do domestic violence, that do um, help victims of crime, and they do it for free. So it is worth the time to research that and find those agencies in your area. And I know for us, if you wouldn't qualify for our services, we don't just say, sorry, you don't qualify for our services. We will find you someplace else to send you so that you're not just out there, flailing about trying to figure out what to do next.
yes. Um, as we are coming under the hour, we have a few minutes left. We have a note from one of my dear friends, Cheryl Borelli. She says that it's an excellent program, and thank you. Thank you so much, Cheryl, for listening. I want to ask you, Jennifer, if you would give us um, a final word, but just an important point that you think is worth leaving the listeners with on on tonight?
So I think for domestic violence, what I've seen over the years is that sometimes a victim will come forward and decide that they're not able to complete the task at this particular juncture, which is 100% okay. What I instruct my staff is that we're going to help them to the best of our ability now and try to get them set up for the future so that when they are finally ready to leave, that they have all the tools that they need. So do all the research that you want and take it at your own pace. Obviously I want people to be safe. And I know sometimes it's not always safe to leave at different points in a relationship. So get all the information you need, get all the resources you need, and know that there are agencies out there to help you.
Thank you so much, Jennifer. We absolutely would love for you to come back to our program and cover some more issues. I mean, at the top of my head, I thought about the family law. We have individuals dealing with domestic violence and family law, and that just adds more turmoil to the situations that they're dealing with. There are individuals who won't go forward to get help that they need because they really fear that their children will be taken away from them, by
Yes.
CYS or, any other children agencies. So I would love it if you can, or another representative can come back and just talk to us more about some more issues.
I would love to come back. We could totally talk about custody, which is really, really important,
Yes.
child support, which sort of goes hand in hand with custody, and then CYS involvement, because I think a lot of people are afraid of CYS and they're not that scary. And I can talk about, how they can be really helpful in a lot of situations.
That would be great. I will get some more dates to you as soon as possible. So Love Bay
Wonderful.
Jennifer is coming back. I want to share your information again for those who may need it. Jennifer is with the Crime Victims Law Project. Again, this is in the United States and Pennsylvania. The address is 204 South Avenue in Media, Pennsylvania. The zip is 19063. Phone number is 610-566-6463. And
And
again,
Minister Tia, if I could give the hotline number for the agency too, because that is a 24/7 hotline. It is answered by a real person. And if you have a legal issue, you need to go through our agency intake first before you get to me. And if you call me, I mean, I'll talk to you, but then I'm going to send you to the agency too. So the
yes.
phone number for the hotline, again, it's 24/7, is 610-566-4342.
Thank you so much for sharing that information. Love Bay, if you want to catch up on previous episodes from our program, you can visit our YouTube channel, Suffering in Silence DV. We thank you so much for joining Suffering in Silence with Minister Tia on Love Bay Afrobeat Music Talk Radio. We're here with you every Friday evening at 7 p.m. Eastern. Love Bay, we are continuing to rise out of the ashes together. Good evening.